Welcome to welcome to the Supreme Court. The first matter we have on today's calendar is Anthony A. versus Commissioner. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. I believe both counsel have received the instructions for our virtual argument today. Is that correct?
Yes, Your Honor.
Thank you very much. So when you're not speaking, if you do me a favor and please mute your microphone, that way we won't have the background noise. We need to keep a clear record of these proceedings. With that, are you ready to proceed?
Yes, Your Honor.
Okay,
Yes,
by the
Your
way,
Honor.
just in case we can't see all the justices on our screens here, they will do a virtual raising of the hand or visual raising of the hand. Once you see that, please stop, and then I will call the justice to ask their question.
Okay, Your Honor.
Whenever you're ready, counsel.
May it please the court, my name is Vishal Garg, and I represent the petitioner Anthony A. I'd like to alert the court that Mr. A is listening to these proceedings via speakerphone.
Thank you very much, counsel.
I'd like to reserve 10 minutes of my time for rebuttal, please.
You have your 10 minutes. Justice McDonald, will you be keeping time?
Yes.
Thank you very much. We cannot, at least I cannot see you on the screen.
I will just interrupt counsel at 5 minutes, 3 minutes, and 1 minute, and we'll notify you when your time is up. How much time are you reserving?
10 minutes.
Thank you.
And you are now on the screen, Justice McDonald. Thank you very much.
Thank you, Your Honor. We're here today because DOC has wrongly labeled the petitioner a sex offender. At every stage of this litigation, the respondent has attempted to shield its procedures from judicial scrutiny. In its brief, the respondent goes so far as to assert that it has, quote, unfettered authority to label inmates as it sees fit, and it further asserts that its authority must be free from judicial intervention. The petitioner asks this court to recognize that the respondent's authority is limited by the petitioner's constitutional rights, and that its classification of him as a sex offender violates those rights.
Counsel, is there an agreement that by both parties that the petitioner is labeled as a sex offender?
No, I believe that the respondent disputes that characterization. The respondent's regulations changed the term sex offender to sexual treatment needs. Before 2011, I believe, the score was labeled as a sex offender score. Petitioner's Exhibit 14 is a request to change some of the portions of the DOC manual to change the language sex offender to sexual treatment needs. That language has not been changed everywhere in the DOC's manuals. Vestiges of the old language still exist. But what's important is that whatever they label...
1 second, counsel. 1 second. Did the fact finder make any findings on that issue?
I believe the fact finder made the finding that the petitioner was labeled as having sexual treatment needs. However, the fact that they have chosen to change the label doesn't change what the score actually designates. You can see in Petitioner's Exhibit 14 that the change in language is not part of a change in policy or a change in what the policy actually means. And the designation, in fact, is not based on whether an individual has sexual treatment needs. It's based on whether, in DOC's opinion, someone has committed an act of sexual misconduct. 2G testified at the Habeas trial that whether or not someone gets an STN score is based on whether they have exhibited problematic sexual behavior. 2G specifically testified that whether or not someone has any need to address their sexual behavior or has any treatment needs is irrelevant to the score. In fact, yes, Your Honor.
You're muted.
Your Honor, you're muted.
My apologies. I didn't see the order of the justice. I'm sorry, but I'm going to do an order of seniority. Justice Kahn and Justice Ecker.
Thank you, Chief. I think it was Justice Ecker, but if he's okay, I just have one
quick question. Thank you. Thank you, Chief, and thank you, Justice Ecker. Counsel, I thought beyond the charge that was nollied because the alleged victim recanted, beyond the sexual assault count that was nollied, there was also testimony and a reliance by the Department of Corrections on your client's own words and admissions in a separate interview about some of the sexual activity that he engaged in, apart from the conduct that was the subject of the charge. So why can't the Department of Corrections, in the context of evaluating a defendant, determine whether someone needs treatment for any kind of sexual deviant behavior? So, for example, trial judges often will say substance abuse evaluation and treatment as needed, psychological evaluation or mental health evaluation and treatment as needed, sexual treatment as needed. Why can't the Department of Corrections decision or label, for lack of a better word, be based on that other evidence it relied on?
Well, so I think there are a couple of points to make here. The first is that the testimony of the person who actually made the score was not that they relied on the petitioner's statements. The testimony was that they relied on the statement that the complainant made to police. I know that the respondent in its brief has asserted that the petitioner has made statements that would justify the score, but the evidence does not bear out that the score was actually based on that. Second, the petitioner's statements do not indicate any sort of sexual offense that the petitioner had committed. I think it's important to kind of point out that there was argument about the interpretation of the petitioner's statements in the proceeding below. The habeas court did not make any findings that the petitioner had admitted to being a sex offender or to committing a sexual offense. And so I don't believe that the record bears out that there are statements that the respondent could or did rely on from the petitioner that would support its designation of him.
Thank you, Chief.
Thank you, Justice Kahn. It'll be Justice Ecker and then Justice Keller. Justice Ecker, you're muted, sir.
Sorry, I don't want to take you off of your argument on the evidence, but I just going back to the Chief's question about the designation itself. Can you just help me out a little? I mean, it seems like since this is a stigma plus based liberty interest, maybe the name does matter. Maybe it doesn't. Maybe it does. I don't know. But there's a difference between, and I understand your point is, look, it was just a sleight of hand, sort of, I think it would be your theory. But there's a difference between saying somebody is a sexual offender, which could be a sort of a status statement or maybe a historical statement about who they are or what they've done on the one hand, and saying somebody has sexual treatment needs, which you may disagree with, that sort of diagnosis, but it's a slightly different label. So can you help me with that as it relates to the due process analysis? The liberty interest. Yeah.
Sure. So I think there's a couple of things. First is that DOC has not actually found that the petitioner has sexual treatment needs. Counselor Tuji actually testified that she is not qualified to make that assessment. She's not a mental health professional. She just assigns the score. The evidence here from Dr. Kingston and from, I am blanking on the name right now, the Board of Pardons and Parole psychologist who interviewed the petitioner in advance of his parole hearing, both determined that the petitioner... Thank you, Your Honor. Both determined that the petitioner does not have a need for sexual treatment. And so the idea that this label is just a determination about his sexual treatment needs is incorrect. In fact, the testimony at the habeas trial was that even when it's determined that someone doesn't have sexual treatment needs, the label, the STN score, remains. As to the stigma that's associated with it, the petitioner's testimony is that in DOC, in corrections, people recognize this as a sex offender label, and that he has suffered from people who sort of recognize this label, the STN label, as in fact a sex offender label, which ultimately is what the label designates, even if it's called something else.
Justice Keller? You're still muted, Justice Keller.
The hand instead of the mic. It's not clear to me what you were asking the habeas court to do when you were before it. Were you asking it to retry and find your client was improperly designated, or were you just asking for a new hearing that gave you what you consider to be adequate due process before the DOC hearing officer?
So there were two parts to the analysis there. There were certain procedural defects in the hearing related to the lack of adequate notice of the evidence that the hearing officer would rely on, as well as the lack of a proper opportunity to be heard. There was also a claim that the hearing officer's classification decision was not based on substantial evidence.
Okay.
I think in light of that, I think that the remedy for that would be not a new hearing, but in order that the DOC remove the STN3 designation. And then presumably DOC would still need to conduct a new hearing or hearing to determine whether or not a lower label is appropriate. But I think that we are asking for both depending on which specific error the habeas court finds.
Did the habeas court make any findings that did he address the due process claims?
Yes.
Okay. And he found there was no denial of substantive or procedural due process.
That's correct, Your Honor.
All right. The criminal court that sentenced your client, was he given a probationary period or a special?
Yes, he was given a probationary period.
Was a condition of his probation sex offender treatment?
No, Your Honor. And I believe, I don't recall if it was his probation officer or someone from the department of, someone from the probation office who testified, but they testified that they would be relying on the determination of the Board of Pardons and Parole's psychologist that no sex offender treatment was warranted for the petitioner.
Probation did?
Correct.
Okay. All right. Thank you.
And so getting back to the procedural due process issues, I think it's important to recognize, I will start with the habeas court's determination of the substantial evidence requirement, because that determination was clearly erroneous here. The habeas court found that the complainant's retraction was based on a lack of memory. That finding was based on a single statement that the complainant made to the state's attorney that she didn't remember what she had told police. However, that was not the basis for the retraction. The retraction was based on her, after she had sobered up, determined that no sexual assault had occurred.
But counsel, but that's still in the record, isn't it?
Yes, that's still on the record.
And that would support the trial court's finding. So there is something in the record that supports the trial court's finding. Just because we would see it in a different way doesn't mean that we reverse on that issue.
I disagree that it supports the trial court's finding that the recantation was about a loss of memory. So it certainly would support a finding that the complainant could not remember what she had told police. The habeas court then drew the inference from that that was the basis for the recantation. There's no evidence in the record that suggests that her later recantation was based on that lack of memory of what she told police.
But you just said the trial court made that inference. Why would that be an impermissible inference?
Because it's entirely speculative. The evidence in the record was that the complainant concluded that no sexual assault had actually occurred, and that was the reason that she recanted. That's what she told the state's attorney, the victim's advocate, and the petitioner's attorney. There was also a sworn statement from the complainant in the record in which she stated that the petitioner had not sexually assaulted her.
But she did tell the police originally that he had.
Yes. And so...
Hang on, counsel. Justice McDonald and then Justice Kahn. You are muted, Justice McDonald.
Sorry. Is the term sexual offense defined in the classification manual?
I do not believe it is, but the classification manual does say, let me see, it defines a sex offender as any inmate with an STN score of 2 or greater.
Right, but Mike, in the appellee's brief, it's pointed out that Mr. Mega testified that we don't classify offenders as sex offenders. We classify individuals as having a sexual treatment need. A sex offender is deemed someone who's on the sex offender registry or has committed a sexual offense in accordance with the general statutes. Where does that come from? I mean, that's what he says, but where's the source or the origin of that characterization of what a sexual offense is?
I am not sure where that comes from other than his testimony. I'm not sure if he's relying on, I don't believe that there's anything in the manual that suggests that they shouldn't use the term sex offender, or that the term sex offender only refers to people who are on the sex offender registry. I believe that was just his own personal characterization of the term, but there's no regulations from DOC that support it.
Thank you.
Justice Kahn.
Thank you, Chief Justice Robinson. I want to go back to the questions that the chief was asking you. I could be wrong on the record, but it was my understanding that the alleged victim had called the police, that there was an audio tape of her original complaint, and perhaps even a videotape of her interview. And if the habeas court had access to her written complaint and her written statements, along with the recantation, why isn't the chief's question to you? I have a similar question. The trial court can look at that, the habeas court can look at that and say, you know what, based on looking at all of this, I agree with the DOC, their classification. I think there's substantial evidence, because this is not uncommon in domestic violence. Even with sexual assault aside, where an alleged victim recants, that doesn't mean there isn't a prosecution. That doesn't mean that law enforcement doesn't treat it as if it occurred. So why isn't that enough to support the habeas court's finding, and for us to not find that it was clearly erroneous, that there was a basis here for the Department of Corrections to suggest that your client needed treatment, not as a sex offender, but treatment for any type of sexual deviation?
So I think there are a couple of things there. First is that the sum evidence standard does not allow for these kinds of classification decisions to be based on a bare accusation without a determination of its reliability when that accusation has not been confirmed. The best case on point is Luna v. Pico. In that case, there was a bare accusation contained in a report written by a prison official. The person who made the accusation refused to confirm it. The hearing officer did not speak with the victim and did not interview the person who wrote the report or anybody else with knowledge of the facts. Under those circumstances,
but that's not the case here. The habeas court had access to both statements from the alleged victim. So why would we substitute our judgment of whether that's sufficient for the trial judge, if the trial judge had access to that,
I see.
if the record is there.
So the reason is that I'm not asking this court to substitute its own judgment as to the reliability of the recantation. The habeas court found that the recantation was based on a lack of memory and was not a true retraction of the complainant's assertion as to what happened. That finding was clearly erroneous because there's nothing in the record that supports the idea that the complainant changed her story based on not remembering. The evidence is that the complainant said that no sexual assault had occurred. So if the habeas had found that, based on all of these factors, that it didn't accept the reliability of the recantation, then we'd be in a different situation.
But aren't you then suggesting that any time a domestic violence victim recants, that the court has to accept that wholeheartedly as truth? That's what you're in essence saying, isn't it?
No, it's not, Your Honor. I'm saying that when DOC makes a classification, they need to take some steps to make an assessment, to make a meaningful assessment as to whether or not the original allegation is credible. And that's not what happened here. Here, the hearing officer...
Isn't that what the judge did here? The judge did precisely that, looked at what DOC looked at, and obviously, unfortunately for your client, made a different assessment. So the habeas judge looked at what DOC had to look at and agreed with DOC that they had substantial evidence for this classification. Now, that could mean that the trial judge didn't think the recantation was sufficient to overcome that for DOC and for him as the trial judge.
May I answer that question? My time is up.
You may, counsel, and then I'm going to ask Justice Keller to ask her question. Thank you.
That's not actually what the habeas court said, though. I mean, if the habeas court had said, I have looked at all of the evidence and I conclude that the recantation is not credible, then we'd be in a different position. But here, what the habeas court said was that the recantation wasn't an actual recantation. It was just a loss of memory. And therefore, it was appropriate for DOC to rely on the complaint. That finding was clearly erroneous and is entirely unsupported by the record. And that's the reason that this court shouldn't rely on the habeas court's determination.
Thank you, counsel. Justice Keller.
Couple of things. I'm troubled by the fact that the hearing officer had a video that she admitted she never watched. Was that a video of the interview by the police of the victim?
Yes, Your Honor.
Okay. Did the habeas court watch that video? Was it in evidence?
I do not believe
No,
it was.
because this was a sufficiency claim, whether or not they had sufficient evidence, correct? Right? So he was restricted to what evidence was before the DOC.
Correct, Your
Now,
Honor.
what did the habeas court have to say about the fact that your client was never notified that they were going to go look at all these other police reports concerning some VOPs, and that those were never discussed during the hearing? In fact, she went and looked at them afterwards. I thought the habeas court said, well, he was notified that they were going to be looking at the rap sheets. But I've seen those rap sheets. I saw them a million times in juvenile cases. They're just a statement of the crime and the conviction or the knowledge, but they don't give you any facts. Is that correct?
That's correct, Your Honor. And the petitioner's rap sheet here is actually part of the record. And it's exactly what you say it is. It's just a statement of the original charges and the charges of conviction.
So the record of the hearing doesn't have all of these past VOPs or whatever Toogie looked at later on. She just did some independent investigation on her own after the hearing was done, correct?
That's correct. And the petitioner was never notified that they may rely on that. The respondent suggests otherwise, but I think there's a couple of things that are worth pointing out here. The first is that Toogie actually admits on the record that the petitioner was not notified that they would be looking at these other reports. I'm trying to find the citation for that.
Counsel, I believe you've answered Justice Keller's question. If you want
Sure.
to eat your own time, you may do so.
Yes, if I could just eat into my rebuttal time for a minute. Thank you, Your Honor. So 2G's testimony here, this is on the July 10th transcript at page 76. 2G acknowledges that the petitioner was never notified that she'd be looking at these other reports. The respondent in its brief seems to argue that the petitioner had notice, and my response to that actually in my reply brief, I recognized while preparing for this argument, suffered from some formatting problems. I think I had intended to italicize something, referred to an italicized portion, and then I don't know if this happened when the brief was converted to PDF, if I made a mistake somewhere, but there was no italicized portion. But I think, and this is Petitioner's Exhibit 5, when you actually look at the exhibit, it's clear that they were going to rely on police reports from the underlying case, and that they'd separately be relying on police or on the petitioner's rap sheet, but contains no notice that they'd rely on the police reports from the prior cases indicated in the rap sheet. And that was just the point that I'd wanted to make and clarify, because I think it wasn't clear from the briefs, and I apologize for that. And if there are no further questions at this point, I will use the remainder of my time for rebuttal. Thank you.
Thank you very much, Counsel.
That's,
Attorney Graham-Davis.
that's 8.5 minutes you have.
Thank you, Your Honor.
Thank you, Justice McDonald. Attorney Graham-Davis? You're muted, ma'am.
I apologize for that. May it please the court, Assistant Attorney General Zenobia Graham-Days. Under oath, Mr. A admitted to rape. The issue that was before Judge Kwok was whether or not he received due process. He was notified of the hearing a month in advance. Wolf versus McDonald requires merely 24 hours. The notification that he received outlined the reason for the hearing. Mr. A had a clear understanding of why the hearing was going to be held, the purpose of the hearing, and that was the incident that occurred on July 18th.
Thank you, Counsel. Justice McDonald?
I'm sorry, I didn't mean to have you stop immediately, but I wanted to get into the queue. Was the petitioner convicted of a sexual offense?
No, he was not convicted of a sexual offense, and that is why we provided him with due process. When a determination is made by the Department of Correction that is based on a non-conviction offense, misconduct outlined in a police report that does not result in a sexual related charge, we offer them notice, a meaningful opportunity to be heard, and a decision that outlines the basis for our determination.
Here's the problem I'm having, and if you have your appendix handy, I'm focused on page 836 and 837. Under S3, which is what the petitioner was assessed at, it says these individuals have a current conviction, a pending charge, or known history of a sexual offense. Now, an offense is defined in law under 53A-24 as meaning any crime or violation which constitutes a breach of any law of this state or any other state, federal, or local law or ordinance for which a sentence to a term of imprisonment or to a fine or both may be imposed. This petitioner did not commit an offense as defined in statute that was of a sexual nature. So how could he be assessed as an S3 when S1 talks about these individuals have no current conviction, pending charge, or identified history of sexual offenses?
Mr. A was charged with a sexual offense.
He was not convicted of a sexual offense.
He was not.
Wait, let me finish. I'm looking at S3. It says a current conviction, that did not happen, a pending charge, that was not pending, or known history of sexual offenses. Where was the offense that of a sexual nature as defined in law?
The offense was when he digitally penetrated his then wife's vagina without her consent. That was the offense.
He was not convicted of that offense.
Yes, he was not convicted of that offense, but that in and of itself is a criminal offense that can result in a prison sentence. It is not.
Explain that. Explain that to me. That makes no sense. An offense has to be it's a crime, right? It's a crime for which the state bears the burden of proving beyond a reasonable doubt. The state could not prove that crime. So how is he a sexual offender?
Well, we do not consider him a sexual offender.
The manual says sexual offense.
That there's a distinction between sexual offender and sexual offense, if I may, Your Honor.
Sure.
The determination is not based on the conviction, because a lot can happen between the date that the incident or the police report is generated and the sentencing date. We're aware of that. We're relying on the information that we have available. Tuji testified that every police report that she has access to has resulted in a conviction. So we're not looking at convictions. We're looking at the underlying facts, the facts that generated the arrest. And in this case, Mr. A was charged with a sexual related offense. Now, between the date that he was charged, arrested, July 19, 2011, and the date that he was sentenced, there was a recantation letter. But that recantation letter was evaluated when we afforded him due process. The fact that this woman contacted the police and said that she had been raped, she was transported to the hospital. She told the medical personnel that she had been raped. She left the hospital. She went to the precinct. She gave a formal statement that she had been raped.
Is the allegation enough to qualify as an offense?
No, it's not. The allegation is not enough, but an allegation is sufficient to trigger due process, and that's what we afforded him. When we are relying on non-conviction information, we are providing notification to help the individual understand why we're looking to make a sexual treatment needs designation. We're giving them a meaningful opportunity to be heard. Mr. A had a hearing on December 27th, 2017, and he had an opportunity to be heard. The determination was...
I'll ask one more brief question and then I'll yield to my colleagues who have been very patient. In the manual, does the manual define an offense in a way that is different than state law defines an offense in the criminal context?
I don't believe, excuse me, it's not about what I believe. The manual does not specify or define offense in the manner that state law defines offense. I think it's not about what I think, but the testimony in this case was very clear that the information that is contained within the police report is the information that's used to determine the classification score. We're not basing it on conviction. We're looking at the information that we have available to make a classification determination. That determination then results in a mental health consultation to determine what, if any, treatment is needed.
Thank you.
Okay, I believe it's Justice Eckert, Justice Keller, and Justice Kahn. Sorry if I don't have that order right.
Thank you, Chief Counsel. First, I'm a little troubled by your comment that he admitted to being a rapist. I don't think we need to dwell on it, but, you know, I think he's actually strongly denied being a rapist at every point. I assume you're referring, I don't want to get too clinical, you're referring to the statement that he touched his wife's genitalia without asking for her permission. He also said he never sexually assaulted her, and the minute that and once she said stop, he stopped. That's what he said. I don't know what's true or anything, but I don't think we should call him confessed rapist. And that really gets to my other question, which is more at the core of the issue, which is when we're using these terms, they're highly charged. Calling someone a sexual offender, a sexual deviant, or rapist is a heavy allegation. And my concern here is that we have a DOC employee in the back room somewhere who's unaccountable, unelected, unappointed. She's not a judge. She did no investigation. She didn't listen to any witnesses. And her designation sticks on a label that's a heavy one. That concerns me. So could you give me, in the context of a due process analysis, some comfort about why we should allow people who apparently aren't even qualified to determine needs for sexual treatment to make this label and make it stick without even hearing any witnesses or doing any investigation?
Mr. A came to his hearing very prepared. He had his own written statement. He testified. He provided a written statement from his public defender, now Judge Bott. He provided the recantation letter, his medical records, the transcripts. Tucci did an investigation. She did an investigation to determine the credibility of the recantation letter. She did an investigation to determine what the ultimate outcome would be. It is true that she looked at other information, but the question then becomes, what does she look at and why? Why? And she testified.
Can I interrupt just to ask one last question, then others have questions? What about the no witness rule? I mean, it strikes me that a blanket no witness rule is pretty hard to justify. Lawyers go in, visitors go in, people go in all the time to these facilities. Before we attach a label like this to someone, why can't we have a little testimony from, not from the victim, I understand that issue, but police officers or experts who know more than this counselor? Is that a defensible claim under Matthews against Eldridge, that there be no witnesses?
Your Honor, with regards to the no witnesses, we are mindful of the fact that it is a prison setting and there are some limitations when it comes to access from the public. Under these circumstances, we are also aware that—
Counselor, I've been in the prison scores of times. It's never been a problem. Never as a prisoner, I should point out. But I just don't see why as a blanket rule you say, well, there can't be a police officer come in.
We do not have subpoena power that would force anyone to come in. We do not want to present a situation where a victim could be re-victimized. We have allowed everyone to provide notarized statements of any individual they choose. But even if Mr. A was not allowed to offer a live witness, that in and of itself is merely harmless error. There is enough information for the decision to classify Mr. A with a sex treatment needs score of 3VN. There is the initial statement that she gave when the police arrived. That is some evidence. There is the statement that she provided at the hospital. That is more evidence. There is the third statement that she gave when she went to the precinct. That is an abundance of evidence. But also, when she recanted, Tucci then went to the rap sheets. She went to the rap sheets to review them, to determine whether or not this was, in fact, a genuine recantation. And what she found was, after this recantation letter was written, this young lady was re-victimized twice again by Mr. A. She had to make a credibility determination. And that in and of itself shows she did not arrive at the hearing with her mind made up. She gave Mr. A an opportunity to be heard. She had to make a credibility assessment, and she took that responsibility very seriously.
Thank you, counsel. Justice Keller. You're still muted, Justice Keller.
In most trials, if you want to show that a victim might be recanting because that's typical of abused women, you need expert testimony. Is Ms. Toogie an expert on battered women's syndrome or sexual abuse?
Correctional Counselor Supervisor Toogie does have training with regards to domestic violence. Okay. And it is that domestic violence training that required her, or it motivated her to look beyond the recantation letter. And it's
does
important.
It qualify her as an expert? Some training.
I believe that her classification training and her domestic violence training coupled together would qualify her as an expert in DOC as it relates to the classification process and procedure. Okay. I don't believe, it's not about my belief, but there is a different standard in a criminal setting. But the objective is not to relitigate this. The objective is to determine whether there is information that warrants a mental health consultation to determine what, if any, treatment may be needed.
I wouldn't call it relitigating. It was never litigated in the first place. He was never convicted or tried on a sexual offense charge. Now, your opponent points out that every other classification where you set up an OAP and figure out what's going to happen to them, you don't classify them as in need of certain kinds of treatment unless one of your psychologists or psychiatrists at the DOC or some expert evaluates the person. But in the case of someone you decide is in need of sex offender treatment, that doesn't matter. You're going to label them in need of sex offender treatment, even though in this case, 2 of your experts said he didn't need sex offender treatment. So if they all said he doesn't need sex offender treatment, what was your plan? Were you going to give it to him anyway? Or were you just going to label him as someone in need of sex offender treatment and not give him any treatment because your experts said he didn't need it?
Your Honor, our experts never made that determination.
Yes, they never did. Kingston did.
Kingston was not our expert. Kingston is not part of the Department of Correction Offender Classification and Population Management team. That was an individual that was called by Mr. A.
Who on your team is a psychological or psychiatric expert who can evaluate people, who has a background or a degree in psychology or psychiatry to determine whether or not they are in need of treatment as a sex offender?
We have a lot of mental health staff on our team. In this case, we did not get there. And we did not get there because Mr. A refused to sign the Offender Accountability Plan. By refusing to sign the Offender Accountability Plan, he never had a mental health consultation.
But if he signed it, he would have acknowledged that he was in need of the treatment, which he was disputing.
We cannot determine the treatment until the consultation is made.
Well, that sounds like a catch-22 to me.
After the class,
you know. Okay. So why did he see Kingston? Who hooked him up with Kingston?
His counsel. Okay. And even though he was hooked up with Kingston, Kingston testified that her diagnosis would change depending on the reason why Mr. A had digitally penetrated his wife. She made it very, very clear that her diagnosis was dependent on whether or not he was looking for a used condom or if it was for his own sexual gratification. The standard that is set by the Department of Correction provides notification as to why there will be a hearing, provides a hearing that gives every individual an opportunity to be heard, and a decision that is based on some evidence. The some evidence standard is a standard that was set by Superintendent V. Hill. That standard has, in fact, been satisfied.
Justice Khan and Justice McDonald.
Thank you, Chief Justice Robinson. Attorney Graham Days, I have just a couple of questions to ask you. First, I do want to say Dr. Kingston, who was the defense's expert witness, was on cross-examination, provided information about the statements the defendant had made, his own admissions. And that's when Dr. Kingston indicated that the diagnosis or the evaluation or the conclusions would change if that information had been available, correct?
Yes, that is page 254 of the appendix.
Okay. And then I'm looking at the trial court's decision at A48. So at A48, which I believe is page 16 of the habeas court or trial court decision, the trial court talks about the recantation, and it says the transcript of the proceeding where her recantation was given to the court indicated that the alleged victim now believed that something different happened instead of what she reported to the police. She no longer viewed what occurred as the petitioner sexually assaulting her. The complainant indicated that she had hit her head, had a seizure, and the seizure caused her to lose her memory or even believe things that are not actually true. And then it says the transcript of the proceeding was part of the record considered by Toogie and cites an exhibit. So was it part of the record before the habeas court as well?
Yes, it was.
Okay. And then it goes on to say a letter from the petitioner's former counsel submitted for the classification hearing similarly reflects that the complainant also apprised defense counsel and the victim's advocate that the events she reported to the police may not have transpired as reported to them. The complainant's use of crack cocaine and later self-reported seizures were claimed by her to have impacted her memory of the events. And the court goes on to say, importantly, the complainant could not recall what transpired, which means that what she initially reported to the police is precisely what may have happened, but that she's unable to recall. Is that the trial court basically saying, I looked at the recantation and the reasons given, and based on that transcript, the court's making a finding that maybe what was originally reported to the police may have been actually what happened. Is that what the trial court is basing its lack of reliance on the recantation?
I think that would require speculation as to what the trial court was thinking. There is no definitive, no, we do not believe that this happened.
Okay. Let me ask you a different question. On A49, the next page, that's where the court focuses in on his own statements. And the court says there was an interview that was video and digital voice recorded. According to the petitioner, he touched the complainant's vagina on the outside and inside, and the complainant kept saying no to the petitioner and that she was not in the mood. Complainant turned her to her side, pushed the petitioner's fingers out of her and pushed the petitioner's fingers out of her vagina. The petitioner then waited a period of time and repeated his contact with the complainant's vagina several times throughout the night. The petitioner indicated that the complainant got tired of him putting his fingers inside her vagina and threw her cell phone at the petitioner, who snapped it in half. How the court is relaying what's on the interview. Did the court have the interview or just a transcript of that interview that if it was, if you know?
I do not know, okay. But I do know that she—
level of detail I'm sorry, I shouldn't have cut you off. I guess that's a level of detail. Where would the court have taken that detail? Other than if it had a transcript or a witness who was reading from a transcript? If you know.
That detail is contained within the police report. The police report that was prepared by the Meriden Police Department on that stemmed from the events that occurred on July 18th and July 19th. That detailed police report is what Tuji also relied upon. When she was asked by the habeas court what was the information that she relied upon when making her determination, it was that detailed police report. She testified that it was the detailed police report. And I think it's not about what I think, but the petitioner, when asked very clearly, did you ever touch her knowing she wasn't given consent? He said, without hesitation, yes, she's my wife. That in and of itself is enough to warrant, at the very least, a mental health consultation to determine what, if any, needs the petitioner may have. That behavior is behavior that should be addressed.
Thank you, counsel. Justice McDonald.
Thank you. I just wanted to follow up on a couple of things on the procedural due process issue. You quote the Supreme Court's, U.S. Supreme Court's decision in Wolf versus McDonnell relating to witnesses, and it says there shouldn't be an unrestricted right, but it seems to cabinet by saying to call witnesses from the prison population. And I'm just trying to figure out what the authority is for the department to ban all live witnesses. In this case, I understood that the petitioner wanted to call a police officer. So how is a police officer in a DOC facility a safety risk that would prevent that witness from being able to testify?
When Tuji was asked about a police officer, she made it clear that it is a process that requires a lot of screening for police officers, for lawyers, but this is a hearing that occurred at 7:30 in the morning. And if Mr. A had invited a police officer, there's no legal obligation for him to appear. If a live witness had been called, the outcome would not change simply because there is some evidence. There is some evidence to support this determination. We're not relitigating the criminal charge. And I say relitigating because the fact that the conviction was not pursued, that in and of itself is considered litigation. It did not result in a conviction, but there was a charge, there was an assessment made by the Office of the Chief State's Attorney, and the classification team is simply making a determination about the sex treatment needs score in order for a...
Oh, sorry. I'm sorry. Finish your thought.
In order for a mental health consultation to occur.
Okay. So, I mean, we hear in the appellate court more often than we hear arguments from inmates over video links all the time. Why couldn't the petitioner call witnesses by video if there was a safety concern about any particular witness testifying?
Your Honor, this was a hearing that occurred in 2017. Right. In 2020, I had no idea that I would be appearing before you via video.
But
the Department of
DOC has been doing hearings remotely for a very long time. Are you saying that they didn't have any video equipment in 2017?
What I'm saying is they didn't have the video infrastructure to accommodate. And it's not just accommodating Mr. A, it's accommodating every single inmate that is part of a classification hearing. We, right now, because of COVID, we are trying very diligently to accommodate the criminal hearings, the parole hearings, the habeas hearings, the civil hearings, all of the hearings via video. But this is 2020, and we're still struggling to do that. In 2017, that was not a thought because we did not, and we still do not fully have the infrastructure to accommodate that.
Okay, but it's clear that the DOC has a blanket policy of not allowing live witnesses. Is that right?
No. The blanket policy with regards to live witnesses is based on what Tuji said as it relates to a classification hearing. I say no because if this were a hearing in a disciplinary context, a hearing based on a disciplinary report, and an inmate said, there's another inmate that has relevant information to help me respond to this disciplinary report, then that inmate may in fact be brought in as a live witness.
Fair enough.
I say,
fair enough. But the blanket ban on live witnesses does exist for classification hearings. Is that what I heard you just say?
There is a ban on live witnesses, but it does not preclude Mr. A from providing a notarized written statement.
Well, but that,
and he did.
That doesn't allow for the determination about demeanor. I mean, all of the credibility assessments doesn't jump off of the paper from an affidavit. My final question, and then I'll let Justice Ecker ask his, is these two individuals did the initial assessment. What authority can you offer us that would allow the same two officials to hear the appeal? What's the authority that says somebody gets to evaluate whether they were fair or accurate? They get to do it themselves and not have an independent individual assess it.
Tuji made the initial decision. It was her determination and her determination alone. She made that decision based on the detailed police report. The appeal was done pursuant to Administrative Directive 9.6, Section 7. And that assessment was done by David Maiga and David Maiga alone. David Maiga did not have to agree with the decision that was made by Correctional Counselor Supervisor Tuji, but he also looked at the information and determined that there was some evidence.
I thought Tuji made the initial determination in consultation with Maiga. Is that incorrect?
That's
incorrect?
Yes, Your Honor. She was very clear about who made the decision. She said it was her decision to make. She was very clear about why she made the decision. She did not testify that she made the decision with Maiga. She did not testify that it was a joint decision. She was very clear, and the notification that she generated.
Thank you very much. I appreciate it.
Can I finish that sentence?
You may finish that sentence.
The notification that she generated was clear that she alone made that determination. And that document is 256 of the record. I'm sorry, Your Honor.
Thank you, Counsel. Justice Ecker.
I just wanted to clear something up. I'm sure it was a miscommunication of some kind, but in response to some of Justice Keller's questioning, my impression was that there was nobody from the state no expert from the state weighing in on the need for treatment. But that's maybe not what you meant, because I see here on page 11 of the appellant's brief that this gentleman, Rentler, who was mentioned earlier, who's supervising psychologist for the Board of Pardons and Parole, was asked to review the case. He was not able to interview the person directly because of this protest that the man was waging to refuse to be interviewed, apparently, but did conclude that a sex offender evaluation was not recommended, and that he was not motivated by sexual motivation, instead reflected, essentially mental illness, and it was his recommendation that he was not required to undergo sex offender evaluation before receiving the parole hearing. Isn't that important? Actually, the state's own expert said that he doesn't need treatment.
No, it is not important, because it is not the responsibility of the Board of Pardons and Parole to determine the manner in which the Department of Corrections, the prison system, classifies inmates. The assessment and the standard that is used inside the prison is not the same assessment and standard that is utilized by the Board of Pardons and Parole. And we have no way of knowing whether or not our mental health team would have shared in that opinion, because Mr. A refused to sign the offender accountability plan.
Well, you could have asked him anyway. I mean, what prevented you from asking your professionals whether he signed it or not? I understand there's some bureaucratic need for a signature, but you could have asked your experts, didn't. The only expert testimony here was that he didn't need treatment, right? The only experts who had any view of the matter said that he didn't need treatment.
Those experts were basing their opinion on their personal area of expertise. An individual that is
Well, isn't that better than basing your view on no expertise, which is what the counselor did?
Our assessment should be based on mental health staff employed within the prison system. Our assessment should be based on our own experts. Mr. A did not have a consultation with our experts, and as a result, we have no way of responding to that. But what we do know with absolute certainty is an expert from the Board of Pardon and Parole, or an expert like Ms. Kingston that has no familiarity with the actual facts or the prison system, is not in a position to offer an opinion that should weigh more than someone that is employed by the Department of Correction within the prison setting, that has experience with prisoners and their needs.
Justice Khan?
So, thank you, Chief Justice Robinson. So what I understand you to be saying, Attorney Graham Days, is that, you can't treat this like a evaluation while somebody's on probation, or an evaluation that's done during the trial. These classifications are for internal purposes of the Department of Correction, to provide services to individuals based on their needs, or the perceived needs, while they're incarcerated, correct? And that once they are out on probation, it's a different assessment and evaluation that has to be done, correct?
It is correct. However, the purpose is larger than that. We have a responsibility to provide help for the individual, programming services to identify needs that they themselves might not be willing to acknowledge that they have, to rehabilitate that person, to keep them safe from themselves, safe from other inmates, to keep staff safe. But it's also important to acknowledge the fact that our objective is to help a person so that they are able to reintegrate into society. It's all of these things.
And so to follow up, a question to follow up with that, this particular individual had actually been discharged. He'd actually been released after the classification was made, and it was that he got rearrested and came back in when that he then sought the hearing. Correct? In terms of the timing, he was already out, and then he came back in, and the classification remained, and that's when he sought a hearing. Is my understanding? Is my timing correct on that?
That is correct. This hearing was done after he returned to prison, after he re-victimized this young lady that wrote the recantation letter. Yes, that is when he was offered a hearing, was given a meaningful opportunity to be heard, and there was some evidence to warrant the need for the classification score of 3VN.
Okay. And so I guess that's right. It came back to the difference to me between a classification for internal purposes to provide help. Now, let me ask you this. Let's say a defendant comes out, doesn't get this treatment, and then offends out in the community and is rearrested. I've heard defendants say, well, you know, of course I was going to offend. I didn't get the treatment I really needed. Judge, at sentencing, you should go easy on me because when I went to jail last time, I wasn't offered any treatment that would help me so that I wouldn't recidivate. So it's kind of a double-edged sword in a way for the DOC, because if you don't help somebody, then the claim is that there was recidivism because they didn't get the help that they needed or should have been recognized. Is that part of your point?
That is my point exactly. And that point bears out with the fact that after Mr. A was discharged, he victimized the person that wrote the recantation letter twice, not once, but twice.
Thank you. Those are my questions. Thank you.
Thank you. I believe this is a question from Justice McDonald.
I'm sorry, Chief, I had failed to lower my hand.
Thank you. Counsel, I believe your time is up. Is that correct, Justice McDonald?
Yes.
So if you'd just like to say a final statement, then you may do so.
Judge Kwok was correct when he determined that Mr. A was afforded due process. Mr. A did receive notification of the hearing. He did have a meaningful opportunity to be heard, and there was a decision that was based on some evidence. This process by the Department of Correction is not arbitrary or capricious. This is a process that is designed to help people, Judge Kwok's decision should not be disturbed. Thank you.
Thank you very much, counsel. Attorney Barr.
Thank you, Your Honor. To start out, I think there are several factual arguments that opposing counsel made during her argument that were made to the habeas court, and they're disputed. The parties disputed these issues, these factual questions, vigorously. These include the import of Dr. Kingston's testimony with respect to a hypothetical she was asked, the import of the petitioner's testimony. The habeas court didn't make any findings consistent with the respondent's position on these. And so I would ask this court not to rely on those representations as an accurate statement of the facts.
Counsel, there's a question from Justice Keller.
Oh.
Justice Keller, you're muted.
Question, Attorney Garg, that on appeal, first of all, before the appeal, Mr. is it Maja or Maja?
Maiga, I believe.
Maiga had discussed his case and worked on procedural changes before this hearing took place, correct?
That's correct.
All right. And then Tukey hears the hearing, and then there's an appeal, and your opponent is denying that Tukey had anything to do with the decision making of the appeal, but you seem to refute that. What does the record show?
The record shows, and this is during Toogi's testimony, my understanding is that what Toogi does is not assign the score initially. Toogi makes a recommendation, and MIGA decides whether or not to accept that recommendation. And then subsequently, several months later, the petitioner presented a report from Dr. Kingston. Actually, withdrawn. I'm getting some of the facts backwards. So my understanding is that both Toogi and MIGA are involved in the initial classification assignment. Whether or not MIGA's role in that is just to rubber stamp Toogi's recommendation, I don't know. But then both of them, again, are involved in the appeal.
And who testified? Who testified to that?
I believe that was Toogi as well.
Okay.
I think it's worth noting that this appeal, frankly, is not a meaningful appeal. They said it took them 30 seconds to deny the appeal.
Counsel, there's a question from Justice Ecker.
Yes, Your Honor.
Along the same lines as the question that came from Justice Keller, I'm just wondering about the impartial decision maker point. Judges aren't allowed by statute, aren't allowed to rehear cases after an initial decision. If there's been a reversal, I don't think we're allowed to hear appeals of our own decisions by ethical rules. And I don't know if those are due process considerations or something else, but was there an initial determination prior to the 2017 determination? Just be clear on that, about the sexual treatment needs status that was made by Toogi?
I don't recall whether the evidence shows that there was a prior determination made by Toogi. I don't believe that.
Okay.
The record reflects that.
So the claim of bias or prejudice or prejudgment or something that's based on the fact that the same people that were involved in the initial determination and the events surrounding it also decided the appeal?
Correct.
Do you have any cases on that? I mean, I saw in is there case law on that? In this context, in administrative decision-making kind of context?
I wasn't able to find anything either way in the administrative context. I think there's an analogy with judicial decision-making where, just as a general rule, judges, there's a presumption that judges should not decide the correctness of their initial ruling. But I don't believe I was able to find specific authority either way in the administrative context. I also want to point out that, oh, sorry, there's a question. Your Honor,
Thank you, Chief Justice Robinson. Counsel, since you seem to be making the claim of bias and that there was, the people who made the classification heard the initial request and then heard the appeal. Can you walk me through what happened? So you don't know when the initial classification was made by Toogi? You don't know that? I mean, it's your claim. Can you tell me on this date, this person made this decision, then there was a hearing, and then there was an appeal, and who decided what? Can you walk me through that?
Yes, Your Honor. So the hearing was in December of 2017.
The hearing before whom?
Before Toogi.
Okay. And that was after her classification?
No, it was based on that hearing that she made the classification of an STN score of 3.
Okay. So in December, she makes the classification. She's the only one involved at that point? As far as
she makes the recommendation that he be classified as 3. My understanding is that MIGA signs off on that recommendation.
Okay. Is that an understanding or is that in the record?
That's Toogi's testimony.
Okay.
I believe it's on page 51 of the July 10th transcript.
Okay, thank you. And then what happens after that?
After that, the petitioner requests that he asks to appeal that decision.
Okay.
I don't know. What the date of that was. I believe it's in Respondent's Exhibit L.
Okay.
The appeal is decided in March of 2018.
Okay.
There's a signature on that from David Miga.
Okay.
My recollection is that Miga disputed his signature on that document.
Okay. And then what happened after March 2018, after that appeal?
I think that was it. I don't believe that there were any further remedies that were available to the petitioner at that point, besides going to court.
And then that's after that he filed his habeas.
Yes.
Okay.
And
Miga and
to clarify, the habeas was in process before that. After that, the issues concerning the classification hearing were added to the habeas and ultimately became the whole basis for it.
Thank you. And Miga and 2B both testified at the habeas about this classification issue.
Correct.
Okay. Thank you, counsel.
Yes, no problem. I think one last point that I want to make is that the respondent argues that live witnesses wouldn't have mattered because the outcome of the hearing wouldn't have changed. And that's essentially the problem here. What Toogie decided is that because there was an accusation, she was going to give the petitioner this STN score, and it didn't matter who testified. It didn't matter what evidence the petitioner presented.
What about his own statement, counsel? What about his own statements that he did sexually assault her because she was his wife?
So I do want to clarify that the petitioner said things during cross-examination, but I think it's important to look at the entire context of his testimony. At the beginning of his testimony, he had an episode of PTSD. He was under a lot of stress. He was asked difficult and confusing leading questions by the respondent. He answered some of those in ways that seemed to suggest that he was admitting to sexual assault. During redirect, he clarified that that's not what he was saying.
But the court heard direct and redirect, correct?
Correct.
I mean the hearing officers.
No. And just to clarify here, this is at the habeas trial.
Okay. Okay. Thank you for correcting that. So the habeas judge heard both what was on direct and what was on redirect.
Correct. The parties argued vigorously as to what the habeas court should conclude in terms of any admissions that the petitioner made. The habeas court did not make any findings or resolve that argument. It found that it didn't need to in order to resolve the case. And so,
explicitly?
No, not explicitly. Sorry. I'm drawing the inference that that wasn't relevant to the habeas court's determination because it didn't make those findings.
And there was no motion for an articulation?
No.
Thank you.
And so ultimately, though, the respondent's position is that an accusation is sufficient for the DOC to forever label the petitioner as a sex offender. That no evidence that disputes that would have a bearing on its decision. And that's a problem. Ultimately,
counsel, that's a hypothetical situation. What you have here is an individual who the trial court heard on direct and redirect evidence that may have actually indicated that he admitted to a sexual assault upon his wife because she was his wife. That was before the court.
Yes, but the court did not rely on that in drawing.
We don't know what the court did. You didn't ask for an articulation.
I didn't ask for an articulation, but I think the court's memorandum of decision set forth all of the factual findings that it made in support of its decision. I don't believe there's any reason to think that the habeas court made factual findings that were not part of its decision.
But they may have been in support of his factual findings, counsel. That's what I'm saying. Justice Keller?
That goes back to the question I had in the very beginning. The habeas court was asked to find whether or not there was sufficient evidence before Toogie, correct?
Correct.
He was not retrying de novo the issue of whether or not this gentleman was a sex offender. Am I wrong in that?
No, that's correct.
Okay, thank you.
Counsel, I believe your time is up. You may do a wrap-up statement.
Just in conclusion, what we have here is an accusation. Based on that accusation, and despite the fact that all of the evidence after it contradicts it, the DOC has decided to label the petitioner a sex offender. They claim it's a sexual treatment needs score, but DOC admits that even if its people examined him, even if its psychiatrist examined him, decided he had no sexual treatment needs, he would still be saddled with that same sexual treatment needs score. And that's because DOC is labeling the petitioner as a sex offender. The basis for the score is DOC's determination that he's committed a sex offense, despite the fact that he's never been convicted of it, despite the fact that the state's attorney was unwilling to even try the case. And that's
Counsel, I'm going to ask you once again, did the habeas court find that he was labeled as a sex offender?
No, the habeas court did.
Factually.
No.
Thank you. Justice Ecker? You're muted.
Sorry, I'm so focused on my hand that I forget my mouth. Just to be clear on that last point, you said in your initial argument, and I haven't gone back to check, that the policies or rules of the DOC define sex offender as anyone with an STN score of 2 or more. Is that true? Is that correct?
Yes, and that's Respondent's Exhibit F. I don't recall the exact page, but I know it is cited in my initial brief in that.
Okay, we'll find it. We'll find it if it's in there. Thank you.
Yep.
Sorry about this, counsel. But at least as was argued before us, the term sexual offender is not the sexual offender as it's defined in the statutes. It's defined some other way here.
It's not defined in the regulations.
Right. And we're not sure what exactly it means at this point. I guess we'll have to look at everything. Thank you.
Thank you, Your Honors.
With that, we will be in recess until the next matter. Thank you very much. Thank you, counsel. I really appreciate you coming in and doing this virtually.